Good afternoon, everyone. Babak Shamsi here with Beresford Booth, PLLC, doing a webinar presentation today relating to judgments. As you can see on the screen, the title is I Won, I Have a Judgment, Now What? Collecting Judgments in Washington State. Essentially, in this process, I'm going to talk about the procedures for what you do after you've received the judgment, whether it be a judgment by default or a judgment after a motion or the end of trial, but this will discuss kind of the various scenarios and possibilities that you have to collect on the judgment that you have received. So this presentation will only pertain to Superior Court judgments. There are different rules depending on the type of judgment you get. Sometimes, district court judgments have some other rules that you have to follow. And so it's important to know kind of what arena you're working in. And this one will relate to Superior Court judgments because by and large, that's what our firm deals with and what a lot of people, inevitably deal with in these cases, usually in Superior Court. And so that's what I'm going to be discussing today. So the first thing is entering the judgment with the court is clearly very important. You have to do that with a judgment summary, which is often found at the very beginning of the judgment. And the judgment summary must contain, certain information in order for it to be entered by the clerk. And it's listed on the slideshow, but you need the judgment creditor's name as well as the name of the attorney representing the judgment creditor. You need the judgment debtor identity on there. The amount of the judgment, of course, and the interest owed to date of the judgment, the total of attorney's fees and costs, if those are known at the time of the judgment. And then, of course, if it's a foreign judgment, so domesticated from another state, for example, you'll need the filing and expiration dates of the judgment under the laws of the original jurisdiction also to be included in there. There's a whole process on domesticating foreign judgments from out of state that I'm not going to be going into here today, but there is definitely a procedure that has to be followed in order to make that judgment effective domestically in Washington State or in one of the superior courts in the counties here. And if you have that kind of situation and want to have it addressed, you can certainly call our office, and we've dealt with that issue numerous times. But I'm not going to go into that today because it's a short presentation and there's a fair bit to cover. So the judgment is entered upon delivery to the clerk's office for filing, and the entry of the judgment commences an automatic judgment lien on the non-homestead real estate owned by the judgment debtor in the county where the judgment is rendered. So I'm going to go into the homestead just a little bit later on in the presentation. That is its own kind of complicated scenario that isn't going to be covered in detail here, but I will briefly address it. But the point is that once you file the judgment with the court, it's automatically attaching to real estate owned in that county. Now, oftentimes title companies will pick that up as they're supposed to pick them up when they're doing, involved in refinances or sales of property, which is often where this will come up. But as a matter of course and caution, my preference is always to record the judgments, against any real property that you were aware of that is in the county. It's kind of a belt and suspenders approach. It is not technically necessary, but I've seen circumstances where title companies will miss a judgment because it's only been filed but hasn't been recorded. And when you record it against the property, that's a much more surefire way to make sure that it attaches. It really depends on the circumstances and just how careful you want to be, but that's my personal preference. When I know there's a piece of property I want that judgment to attach to, I'll do that through the recording process. In order to attach the judgment in a different county from where it was actually obtained, so for example, if you got a judgment in King County, but you wanted it to attach to non-homestead real property in Snohomish County, you have to get a certified abstract of the judgment and file it with the clerk of the county where you want that judgment to attach. So in that scenario, you would get a certified abstract of the King County judgment and file that in Snohomish County in order for that to affect the real property in Snohomish County. And again, I recommend the recording process as well as a more sure way of making sure that the title companies will pick up on it. Note that the entry of the judgment, however, does not create a judgment lien on personal property. You have to execute on personal property, which I'm going to be discussing in a little bit here. So how long does your judgment last is a very important question. Generally speaking, it's governed by the RCW 1617020, and it's essentially 10 years. Now, there is also a process to follow where you can essentially renew your judgment for another 10 years after that. And there's a time frame that you have to follow in order to do that properly. And so your judgment can actually last you essentially 20 years if you follow the proper procedures. So, if you have a judgment debtor who doesn't have assets now, or you have reason to believe that judgment debtor may have assets in the future, you can effectively, for lack of a better word, haunt your judgment debtor with the judgment because it lasts for a significant period of time. You just need to be careful and make sure you're aware of when that first 10 years is going to expire, because the time frame for which you renew the judgment, if you will, for the next second 10-year period is going to depend on when the first period expires. So you really need to be careful and make sure you have awareness of when you got your judgment, when that 10 years is going to expire. There are exceptions that I'm not going to really go into today because they're pretty specific circumstances. But for example, child support or criminal restitution, there's differences there for how those goes. But generally speaking, you have it 10 years, and then if you renew it properly, in accordance with the statutory requirements, you can get it for another 10 years. So what can you do with your judgment? That's a pretty important question, and probably the question on everyone's mind, which is how do I collect on this thing once I have it? Well, you can do executions on personal property, execution on real property. You can do garnishment, that would be bank garnishment or wage garnishment. And then in the event that you don't know much about the assets of the debtor, you can do what's called supplemental proceedings. These are just some of the examples of what you can do with a judgment once you have it. These are the ones I'm going to go over today. There's some other interesting issues as well that I'm not going into today, like getting charging orders against LLCs and the like. But this is kind of a lot of the basic and most common things that you see when you're looking to collect on the judgment that you have received. So first I'll go into execution of personal property. So in this circumstance, you can execute on people's jewelry or, furnishings or carpets or, whatever it is, cars that they own in order to satisfy your judgment. It's governed by RCW 6.17 generally. And there's a series of documents that you need in order to make this happen. And I've listed them there. There's the precipice, which is essentially a request for a writ. Your writ of execution on personal property so that you can actually execute on the personal property. And that's done through the sheriff's office, as I'll explain shortly. Some counties will require you to actually get a separate motion in order to break and enter with the court. A lot of counties don't require that, but some do. So you need to be aware of the specific requirements of the county in which you're operating. And as a general rule, you need to be aware of that anytime you're dealing with the sheriff's office too, because the different sheriff's offices have different requirements on how these things go, from requiring an order like that to what kind of bond they're going to require to what their general process and intake process is and how they want payment. I mean, every detail. So you really need to have a good rapport with the sheriff's office that you're working with, just to make sure you understand their nuances, because the less you frustrate them, the less you'll get frustrated, has always been my experience. And so you just kind of need to be aware of that. So as I was talking about the sheriff, you need the sheriff's indemnity bond in a lot of circumstances, and of course an instruction letter to the sheriff as to what you want to do, and then your affidavit of mailing. So the general process, and I'm not going to go into all the specifics because I feel like each one of these could be a presentation on its own for far longer than the entire time I have here today. So this is really high level, kind of 30,000 feet above sea level, looking at each of these processes. But generally, you deliver the precipice and writ to the clerk. As I mentioned, some counties are require a court order to break and enter. And then when you have your writ, you deliver it to the sheriff with copies, a copy of the judgment, and the indemnity bond. The bond is typically double the value of the property that you're going to levy, but it really depends, again, with the sheriff's office and the general situation, case-by-case basis. And so, different offices have different requirements, and different circumstances may cause the sheriff to take different positions. So again, communication is key. And then there's a process by which the judgment debtor can assert an exemption, and there's a whole statutory process and layout as to what the exemptions are and how much and all of that. But the judgment debtor can assert exemptions prior to the sale, and then the creditor has 7 days to object to that. And then with regard to the sale, RCW 6.21020 governs sort of the sale process. And no less than 30 days prior to sale, the judgment debtor will have to send a notice to the judgment debtor about the sale. So giving basically notice of the sale at least 30 days before the sale by regular and certified mail. And then no less than 4 weeks before the sale, the sheriff also posts a notice, and oftentimes the sheriff will work with you in terms of the contents of the notice and getting that all together. And they'll post it in 3 public places in the county where the sale will take place. So you need to make sure that the notices are provided, otherwise you may not be able to go forward with your execution sale. And it's not only the sheriff that provides the notice, but the judgment creditor has to too. And so you just need to make sure that you coordinated with the sheriff and got everything out the door and all the parts are moving at the same time so that you can have your sale take place. And generally speaking, sales on personal property take place between 9 a.m. and 4 p.m., essentially business hours. It's a little different with real property executions, as I'm going to get to in just a minute. By a minute, I mean right now. So execution on real property is governed by RCWs 6.17 and 6.21 both. And there's a kind of a lengthy kind of statutory scheme involving personal property executions. And so generally speaking, before you can go and execute on real property, you have to have exhausted the personal property. You have to provide an affidavit as to exhausting non-exempt personal property first. Now, that can take the form of, you've already done some personal property and there's nothing left, and so you're going after the real property. Or it could simply be that, your judgment is so large that the personal property couldn't cover it, and so you have to execute on real property. There's a number of scenarios that are kind of outlined as to what's considered exhaustion of non-exempt personal property, but essentially you have to represent that you can't go after the non-exempt personal property, and you need to go after the real property in order to satisfy your judgment. And then you can go towards the real property. So there is a homestead exemption for people who reside, owners who reside in the property as their primary residence, and there's some requirements there. But there is an automatic homestead. It used to be you had to declare your homestead and actually have a declaration, but now it's generally automatic, and there's a few requirements there as well. But generally, the homestead exemption amount is the greater of $125,000 or the county median sale price of a single-family home in the preceding calendar year. Now, that was enacted just about a month ago, and that was a huge change. It used to be a homestead exemption of $40,000 some years back, I think prior to 2007. And so in that circumstance, only the first $40,000 of residence was going to be exempt for the debtor. They changed that and made it $125,000, which is obviously significantly more. But if we all know about how much properties go for sale in the Pacific Northwest and Washington State, and especially in Western Washington, it's pretty expensive, and it's getting more expensive around here, right? So the recent change is, I think, a huge change to the homestead exemption because it's looking at the median price of single-family homes, and that could be quite a bit higher than $125,000. So something to be aware of, and make sure you understand what that is going to be, so that you know how much the exemption is going to be and how that's going to affect your decision to execute on real property. There are some exceptions, for example, mechanics liens or deeds of trust that have been acknowledged. For example, if it's community property, if both of the husband and wife have acknowledged and if their notarized signature on there, or if it's owned by one unmarried person, that their signature has been notarized, but essentially acknowledged in a way that the deeds are acknowledged. So sometimes banks that are doing, non-judicial, judicial foreclosures sort of can get around this. And then there's a process, again, you file your precipice, which is your request for writ, along with the affidavit that I mentioned previously. And then you obtain the writ of execution, deliver it to the sheriff, and then the sheriff will schedule a sale. And the sales are generally scheduled on Friday, unless there is a holiday on a Friday, which it goes to the next calendar business day. And then once the sale is over, you have to move to confirm the sale. Sometimes there'll be issues pertaining to surplus funds, and junior creditors might make application to get surplus funds, and so there's a whole scheme with that. There's a lot of equity in the property, and it's been sold, and your judgment is satisfied. There may be money left over, and there may be other creditors with their hands out who want that too, who are behind you because you got your judgment before they did, or something similar. So you confirm the sale, maybe there's a disbursement of funds, and then there's a redemption period, possibly. And the redemption period is dictated by statute, and there's a variety of different circumstances involving that. It's important to go through and understand whether or not there's going to be a redemption period and how long it is. And the redemption period means that the judgment debtor or qualified redemptioner, as defined in the statute, can pay a certain amount of money in order to redeem the property and effectively pay you off out after the sale. So that's the execution part, whether it's personal property or real property. Another major area is bank garnishment and wage garnishment, essentially garnishment, where you can essentially collect funds from the debtor through either their financial institutions and accounts, and there are certain account types that are exempt and other ones that are not, but I'm talking here about kind of your standard bank account. But there are other issues, pertaining to, retirement accounts and that you have to be really careful to make sure that, the entire account you're dealing with is not exempt. But essentially you can go with a bank garnishment, or you can do a wage garnishment where you essentially garnish through the employer for the ongoing wages. So bank garnishment, it's a very detailed process. There are a lot of specifics, and you really have to follow the letter of the law and what you're doing, and making sure that you get it right, right down to the number of copies you're giving and who you're giving what to, and making sure you've given everybody the notice they need and served it in the right way, because it's easy to mess up if you don't know what you're doing, and there can be some serious consequences. So generally speaking, the important documents are your application for writ, your writ of garnishment, the answer, which is what the bank uses to say, yes, we have, this amount of money that is, not exempt, for purposes of, that the debtor has, that, essentially they can pay out. Your notice of garnishment, the exemption claim, because the debtor may claim exemptions here. There's a process I'm going to talk about briefly with that. And then your creditor's affidavit. So essentially, the general process is you present the written application to the court, you get the writ, you serve the writ and the answer with an answer fee on the garnishee, either personally or certified mail, return receipt, so to the bank garnishee. And then you also serve on the debtor the copy of the writ, the creditor's affidavit, your notice of garnishment, and exemption claim form, so that the debtor has that too. So you just got to make sure to send everything to the right people, follow the process appropriately. And then the debtor can respond on the exemption claim. And if the debtor responds on the exemption claim and you object to that response, a hearing will be scheduled. And at the hearing, the debtor has the burden of proving their claimed exemptions. And there's a prevailing parties clause. So, if they fail on that, the plaintiff can recover their attorney's fees and costs, or vice versa. And so it's important to make sure that the debtor gets that information. And then if the debtor does claim an exemption, to respond and act accordingly, if you believe that the exemption claimed is incorrect, that the debtor is acting incorrectly or is wrong about it, certainly object and deal with that. So definitely an important and extensive process. But the good part about bank garnishment is, if a debtor has significant funds in a bank account, you could possibly partially satisfy your judgment in a real significant way, or fully satisfy your judgment on one hit of a bank account. So it can be a very efficient and quick process to satisfy your judgment in collection, provided that the debtor has significant funds in an account that you can deal with. And there are ways to locate those accounts. There's investigators and that kind of thing who do that work. you need a valid legal reason to do that investigation, and having a judgment is generally that. You can also obtain a judgment against the bank garnishee if they fail to answer and get a default there. And there's kind of a process of dealing with that too. So bank garnishment is one way in order to collect. The other major form of garnishment, of course, is the wage garnishment. It's a similar process. There are some differences to be aware of. One example is that you don't have to give an answer fee to the garnishee because essentially the answer provides that the fee will be withheld on its own terms. But essentially, wage garnishment is nice because you can kind of have an ongoing garnishment of an employer's payments to their employee, in this case, the judgment debtor, towards satisfaction of the judgment. Now, that may not be as quick as a bank garnishment if there's significant funds in the bank, and depending on how much an employee is paid, it may or may not be worth pursuing a wage garnishment. But in some circumstances, it can be useful to do a wage garnishment and essentially collect payments over time through the garnishment process. And then there are exempt amounts, and it kind of depends on the type of judgment you have. If it's private student loan debt, which it'll be the greater of 50 times the state minimum wage or 85% of the debtor's disposable wages. For consumer medical debt, it changes 35 times the state minimum wage or 80% of disposable wages. For child support, it's 50% of debtor's disposable wages. And for general judgments, it's either 75% of disposable wages or a minimum amount determined by reference to the employee's pay period as calculated in the answer. So the employer's got to do a bit of calculations there in order to make that determination. And the general judgments are typically what you're going to deal with, although sometimes you may be involved in, for example, child support debt or that kind of thing. But there are exemptions you should be aware of because you can't simply take all the wages for, I think, somewhat obvious reasons. These protections are put in there also for the debtor so that they have funds left over from their employment as they're working. So wage garnishment is another useful process. It just kind of depends on what you know about the debtor. So what you know about the debtor can be really important. You want to know what personal property they have and what value it is. You want to know what real property they have and what value it is. You want to know, where do they work and how much money do they make and how secure is that income and employment. And then you want to know what bank accounts they have. Where do they bank and how much money they have in those bank accounts and so on. And so that leads to supplemental proceedings. So what if you don't know anything about the debtor's assets, or you don't know enough about the debtor's assets to really know how to collect on the judgment? Well, there is a mechanism where you can call in the debtor for questioning in order to determine their assets for purposes of collection efforts, and those are called supplemental proceedings. You have to file a motion and order for supplemental proceedings, get a court order. Oftentimes, in court orders have a pretty extensive, detailed list of the topics and issues and specifics of what the examination is going to be about. And there's kind of a format to follow to make sure that you do it properly. But once you get the order, you have to serve it on the debtor. So generally speaking, that's personal service or substitute service, essentially serving a co-resident of suitable age and discretion at the debtor's residence. Unless the court allows for alternative service for good cause, you can get an order from the court allowing alternative service under certain circumstances. So you can serve the debtor by mail, for example. But essentially, it requires the judgment debtor to show up to essentially under oath tell you about the assets that they have and kind of give you the information you need in order to collect through whether it be garnishment or execution. And in certain circumstances, you can bring in third parties, and there's a list of third parties qualified for that. But essentially, this is one good way to find out more information about the debtor. And the plaintiff who is conducting the supplemental proceedings is entitled to the cost of service, notary fees, and an appearance fee, and can recover attorney's fees and costs if the judgment debtor fails to appear, and in some circumstances can even obtain a bench warrant. Essentially, the debtor is legally obligated to appear at supplemental proceedings, and not to do so is a serious violation, and the courts don't look too kindly on that. So essentially, supplemental proceedings can be a great way to find out more. And finding out more can be kind of the first step towards knowing what to do next. So even if you don't know too much about where your debtor banks, where your debtor works, what kind of assets they have, what property they own, do they own the house, or anything else? Do they have any other interests in companies that you can attach to, or anything like that? There's a process and a way to find out more. So in summary, really, once you have your judgment, it's not really the end of the story. You've essentially, yes, you've won, but now you have money that you can collect on. You have time to do it, as I mentioned, the 10 years plus the 10-year possible renewal. And there are multiple mechanisms that you can use to get there. Execution and garnishment of different kinds to help you collect on your judgment in order to go there. And it can be a difficult process. It's certainly a complicated process. I highly recommend retaining counsel to assist you with that. We've certainly done that work here. The devil's in the details when it comes to the collections process. But the good news is that there's a way to collect on your judgment oftentimes, and even if there isn't one right now, there may be in the future, and you've got something to help you in the future to collect on those. And even if you don't know how to collect, there is a way to find out. So there's a lot of options there. And if you have any questions or want to discuss anything that was presented in this webinar or generally about the collections process, do feel free to give me a call. My email and my telephone number are both on the last page of this slide here. I appreciate everybody bearing with me today. I hope you all have a nice pending weekend and enjoy the lovely weather today that we're having. And thanks so much for your time.